Good day to all our law students across the Philippines. Welcome to Central Book's Best Pre-Week Ever. Our pre-week bar lecture series is a discussion of all the codal provisions and latest jurisprudence as decided by the Supreme Court. This is presented to you by Central Books in partnership with the Philippine Association of Law Schools, Polytechnic University of the Philippines or PUP College of Law, and Association of Law Students of the Philippines National. This is just one of the many lectures in our Central Books Best Pre-Week Ever Lecture series with plenty more to look forward to, including the following: political and public international law, commercial law, taxation law, criminal law, civil law, labor law, and legal and judicial ethics with practical exercises. Like and follow the page of Central Books to remain updated with the dates and speakers for each program. We would also like to recognize our main sponsor for this initiative, Central Books, and our main collaborators, PULSE, PUP College of Law, and the ALSP National. Ladies and gentlemen, without further ado, let me introduce our esteemed lecturer today for Political and Public International Law. Our lecturer today is a dedicated and accomplished professor of law with a strong background in legal academia, specialized expertise in various fields of law, and extensive involvement in diverse professional engagements. A proven subject matter expert in political and public international law, natural resources and environmental law, constitutional law, international law, and indigenous peoples law. A sought-after bar reviewer and MCLE lecturer contributing to the development of legal professionals. At present, he is the Dean of the School of Law at the University of Baguio and serves as a Board of Trustee for the Philippine Association of Law Schools. He is also a Professor of Law at the University of Baguio School of Law, a Bar Reviewer in Political and Public International Law, and a Mandatory Continuing Legal Education or MCLE lecturer. Additionally, he is a member of the Singapore Institute of Arbitrators and the Philippine Military Academy Board of Advisors. He acts as a learning service provider in policy and governance, environment and indigenous peoples law, a subject matter expert in human rights, environment and climate change, a legal specialist for the Mineral Industry Coordinating Council, and a legal consultant for various organizations and companies. He earned his Master of Laws from San Beda Graduate School in 2013, his Juris Doctor from St. Louis University in Baguio City in 2004, and his Bachelor of Arts in Social Sciences, majoring in Economics and Political Science from the University of the Philippines Baguio in 2000. He is currently pursuing a Doctor of Juridical Science at San Beda Graduate School of Law. In 2022, he served as a Philippine delegate to the 21st International Informal Seminar on Human Rights and Climate Change in Luxembourg, and as a Philippine negotiator to the Convention on Biological Diversity in Montreal, Canada, during the SBS TTA and WGRI in 2014. Additionally, an official RP delegate to various international conventions and meetings, passed the pre-judicature examinations administered by the Supreme Court, and a lecturer, trainer, and resource person on environment, climate change, biodiversity, IPRA, and related laws. He is also a subject matter expert in free, prior, and informed consent. Let us all welcome Dean John Ray Libiran.
Hello everyone. I'm honored to be of assistance to you in your bar preparations. So for this session, we'll try to cover some of the previous bar exams questions on political and public international law. Now, the first thing that I want to discuss today is amendment and revision. This was indicated in your syllabus, and for you to answer any question on amendment or revision, you first need to distinguish what amendment means and what revision means. So in 2004, they asked this question and said, an amendment to or a revision of the present constitution may be proposed via a constitutional convention or by Congress upon a vote of 3/4 of all its members. Now, the call of the question is there a third way of proposing revisions or amendments to the Constitution? If so, then how? Now, we need to know the black letter law to be able to give a correct answer. So, the black letter law is found in Article 17, Section 1. In Section 1, it says that any amendment or revision may be done in two ways. The first one is through a CONAS, Congress constituting itself as a constituent assembly, and the second one is through a CONCON, or a constitutional convention. Now, the question says, is there a third way of proposing amendment or revision? And the answer is, as insofar as amendments are concerned, yes, there is a third way. In Section 2, it says that an amendment may be done through initiative. But take note, and I underlined them here, in Section 1, you can do amendment and revision, but in Section 2, you can only do amendment through initiative. So, going back, there is a third way of proposing amendments, but there is no third way in proposing a revision. But since we're here already, I want you to take note that, of course, you know already the definition of amendment and revision, but I want you to take note that even if they are only trying to change a few provisions in the Constitution, it could also be regarded as a revision in that if it changes substantially the instrument. For example, we just want to introduce federalism, so they will just say, oh, we will change the system from being unitary to federal, and they cannot insist that it is just an amendment because it will drastically change the entire Constitution. You'll have to scrap local government. You'll have to make changes as to the branches of government and so on and so forth. Now, in 2014, they asked this bar question, and I feel that this is something that they may ask in the next bar exam. Because I don't know if you're following the news, they've been talking about whether the vote is just in the House of Representatives, or do they need also to add the votes in the Senate? So in 2014, they asked this question. They said that there were 290 members of the lower house, but maybe don't be limited to the number in the Constitution. It says 250. That is only for the members of the House of Representatives who are elected at large. The same article says that the members of the House can also come from the party list. Hence, it could be more than 250. So in this particular question, they said that there are 290 members of the House, and there are 24 senators. Of course, the number for senators is provided for by law, by the Constitution. So the facts here indicate that 275 members of the House already voted and approved the proposal to amend the Constitution, but in the Senate chamber, there were only 10 who said yes to the proposal. And so the call of the question is, were the proposals validly adopted by Congress? So going back to the black letter law, it says there that you can make changes upon a vote of three-fourths of all its members. So that was the words used by the law. Now, probably the number 275 is compliant with a three-fourths vote. If you do it in decimals, then that's 0.75 or 75% of their membership. So 275 could be 75% of the membership in the lower house, but is 10 out of 24 75? And the answer is no, because you need 18 senators in order for you to say that you got 75%. Now, how do we compute that? Do we add the figure 275 plus 10 and then just add the 290 plus 24 and then you divide it? That is a question, and they ask, what does three-fourths of all its members mean? Fortunately for us, there is a jurisprudence, an old one, Miller versus Mardo. And in that case, the Supreme Court said that when you say all its members, then it indicates that you need to count them separately because there are two chambers of Congress. Okay. Now, you will see that the term they used here is Congress, and please note that they don't interchange Congress with the House of Representatives. It's us who are prone to do that, because maybe we call our congressmen, and therefore we associate them with Congress. But the Constitution is very clear when it uses the word Congress. It refers to two chambers. For example, when the Constitution talks about impeachment, it says impeachment happens in Congress, but then the prosecutors are the members of the House and the judges are the members of Senate. So please take note of that. Now, let's go to the national territory. So this was asked in the 2009 bar, but this is a frequently asked question in the bar. So the facts in this question tells us that there is a private American citizen who was inside the U.S. Embassy in Manila. He got into an argument with a Filipino, and because of the argument, he killed the person. So the police came. The police went to the embassy and took custody of him and brought him to the police station. So he was informed of his rights and so on and so forth. But William, the American citizen, protested his arrest, and he argued that since the incident took place inside the U.S. Embassy, the Philippine courts have no jurisdiction because the embassy grounds are no longer part of Philippine territory. So the call of the question is William correct? And they want you to explain your answer. So if we will summarize this, then we can probably restate the question saying, are embassies part of the territory of the receiving state? Now take note that territory is different from jurisdiction. Going back to Article 1, which describes the Philippine territory, it says there, the national territory comprises the Philippine archipelago with all the islands and waters embraced therein. Now, obviously, the U.S. Embassy is found in Manila, and Manila is within the Philippine archipelago. So to answer that question, is the embassy still part of the Philippine territory? The answer should be yes. And so, what did we learn in Revised Penal Code? Crimes are territorial. and it is applicable uh, uh, for all who live and sojourn in the Philippines. So this American citizen may be prosecuted for violation of a crime, but the caveat here is um, maybe they will change the question. So you have to determine if that person has diplomatic immunity. Because if he has, then his person is inviolable. Okay? So take note that under Article 2 of the Revised Penal Code, uh, our penal laws are enforceable anywhere within the Philippine archipelago. So, just to summarize this one, embassies are still within the territories of the receiving states. The only issue here is whether or not they can exercise jurisdiction over persons and incidents there, because under the Vienna Convention on Diplomatic Relations, there are certain immunities that are afforded diplomats and diplomatic envoys. This is another tricky subject matter when we talk about national territory. So this was asked in the 1989 bar. It says, what do you understand by the archipelagic doctrine? Unfortunately, there are a lot of books that still teach us that the archipelagic doctrine is the phrase saying the waters around, between, and connecting the islands. That's not really the archipelagic doctrine. If you look at the definition of national territory, you need to divide this into three parts. The first part, saying the national territory comprises the Philippine archipelago, is the territory per se. It's the one that says that the archipelago should be treated as a single unit, and that is what is known as the archipelagic doctrine. Now, take note that for an archipelago, it is difficult to determine the metes and bounds of their area. Hence, we devised this archipelagic doctrine in order to determine what is the area for an archipelago. I mean, for countries with contiguous and a single land mass, it's easy to determine their territory. But how about for archipelagos where there are islands and waters? So the first part really describes the archipelagic doctrine. It simply says that an archipelago shall be treated as a single unit. Now, that first part also talks about the territory per se. And if it is territory per se, then you have full sovereignty over that. Meaning you can enforce criminal, civil, and administrative laws. The second part talks about all other territories over which the Philippines has sovereignty or jurisdiction, including the maritime zones. Now, take note that in those areas, we only have sovereign rights. Sovereignty is different from sovereign rights. When you say sovereignty, you have full and plenary powers. Sovereign rights, you only have certain rights. For example, when we talk about the contiguous zone, we have sovereign rights to prevent and punish violations of our customs laws, immigration laws, sanitary laws, and currency laws. And then moving further out, when we talk about the exclusive economic zone, we only have sovereign rights to use all the living and non-living things there. Now, a while ago, I said this is tricky because a lot of books still say that the last part, which says the waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimension, form part of the internal waters of the Philippines. And they indicate and say that that is the archipelagic doctrine. That is wrong. You know why? Because it simply describes the internal waters of the Philippines. So, going back, archipelagic doctrine simply says that an archipelago shall be treated as a single unit. That is the doctrine. Okay, let's move on to another topic which is always asked in the bar exams. They just change the facts and the circumstances, but there will always be a question on state immunity. So here in 2017, a very basic question: what do you understand by state immunity from suit? And we find that in Article 16, Section 3, saying the state may not be sued without its consent. But I like doing this exercise to drill myself. When it is stated in the negative, I try to restate it so that it is said in the affirmative tone. So what I do is I rephrase this, so this will look something like the state may be sued provided that it gives its consent. So if you do it that way, then the next question is, how is consent given? Now you know that consent for purposes of state immunity is given in two ways. Now, the first one is express consent, and express consent is given by virtue of a law. So the state will have to legislate so that it can give its consent. And then the second manner by which consent may be given is by implied consent. In implied consent, it could be because the state entered into a commercial contract, and therefore some authors say it stooped down to the level of the private individual or whoever he contract or whatever, wherever it contracted with. And then the second implied where it impliedly gave its consent is when the state was the one who sued a person or entity and it exposed itself to a counterclaim. So we need to go back to the doctrines and find out when it is a suit against the state. So how do we know that it is a suit against the state? That's simple. All you need to do is find out if the complainant wins, if the petitioner wins, will it entail an action from the state that will involve its money, property, or interests. So even if even if it is the public official that was impleaded, if there will be an affirmative action of the state that that involves its interests, money, or property, then it is considered as a suit against the state. I feel that this is a ripe topic for a question in the bar on state immunity. So the one bar question was asked before, and it said, do government-owned or controlled corporations also enjoy the immunity of the state from suit? Now, to answer this question, we need to find out if the GOCC is incorporated or unincorporated. Now, what does incorporated mean? It simply means that there is a charter, there is a Republic Act, or there is a law that creates that GOCC. And of course, unincorporated GOCCs are those that do not have that, which includes GOCCs that are registered under the Securities and Exchange Commission. So as a general rule, GOCCs that have their own charters usually may be sued. Okay? Because their charters would usually say that this GOCC may sue and may be sued. Now, I said that state immunity also extends to public officials, but only in the performance of their official duties. Okay. Now, in 27, they asked this: may such officials be sued nonetheless to prevent or to undo their oppressive or illegal acts, or to compel them to act? Now, this question is actually leading us to the answer already. If you look at the call, it seeks to elicit that action to prevent or undo, and then to compel the government to act. Now, I repeat this, if the suit involves the property rights or interest of the state, then even if the suit merely impledes public officers, it is still a suit against the state. So public officials may be sued in their personal capacity if they acted illegally or if their act was ultra vires, beyond the scope of their authority. Now, the action that this question is pointing us to is, of course, mandamus, because that is a suit where you can compel the state to do something, or prohibition, which is an action to stop them from doing something. There were several questions that were asked already in the bar when a state is sued, and the call of the question would ask whether that suit will prosper. So this question in 2013 was about a state that entered into an agreement with a domestic corporation. The agreement covers certain works that are to be performed in the embassy. Now, when the state terminated the agreement with the contractor because allegedly the contractor didn't comply with the agreed maintenance standards, the contractor filed a case against the state in the Regional Trial Court of Makati. Now, the question asks, the ambassador now wants you to file a motion to dismiss claiming state immunity. And in Section 10 of the agreement, Kafiristan expressly waived its immunity from suit. So the question is, under these facts, can the embassy successfully invoke immunity from suit? Now, you know that immunity from suit extends also to other state by virtue of that Latin maxim par in parem imperium non habet. And to determine if the foreign state may invoke state immunity from suit, we need to find out if the contract is pursuant to its iure imperi function or iure gestionis. Okay? Of course, iure imperi is in the exercise of its sovereignty, and iure gestionis is purely commercial or patrimonial. Now, obviously, the upkeep of an embassy is in the exercise of the state's sovereign function. All right. So in this case, yes, you can file a motion to dismiss on the ground of state immunity by stating that it was not an ordinary contract that was entered into, but one that involves the exercise of Kafiristan's sovereign function. Now let's leave that topic and proceed to delegation of powers. So in 2002, this question was asked. It says, suppose that Congress passed a law creating a new department, the Department of Human Habitat. It authorized the Secretary to promulgate implementing rules and regulations. Suppose further that the law declared that the violation of the IRR so issued would be punishable as a crime. Okay, so right off you know what the question is, because it talks about subordinate legislation that will provide penal sanctions. So the question goes on and says, can it be provided, in the IRR and regulations promulgated by the Department Secretary, that their violation will also be subject to the same penalties as those provided in the law itself. So if we will identify the issue in this case, then obviously we will have to arrive at delegation of powers. Okay? So the answer to this question is the offenses, the penalties for criminal offense should be indicated in the law itself. It cannot be left to the secretary to determine, and it cannot just be found in the subordinate legislation or in the implementing rules and regulations. So the fixing of penalties for criminal offenses is a purely legislative function and cannot be delegated to an administrative agency. All right. Now let's talk about the fundamental powers. But before I go to the bar exam questions on fundamental powers, I would like to remind you that there are three fundamental powers, right? Police power, eminent domain, and taxation. Now, if they will ask if you can find these powers in the Constitution, then what should be your answer? The answer should be no, because that's the truth. They may be exercised by the state even if they are not provided for in the Constitution. Now you might challenge that and say, but yeah, they are in the Constitution. I read taxes in the Constitution. Yes, you might have read that, but what's in there really is a limitation to the exercise of the power of taxation. Now, police power is not there. Eminent domain is there, but what is indicated in the Constitution on eminent domain is also a limitation. What does it say? Private property may not be taken for public use without payment of just compensation. So, the exercise of these fundamental powers are really inherent even without the Constitution. Now, this question in 2022 talks about a city ordinance that mandates the removal at the owner's expense of all outdoor advertising materials. And the ad agency, ABC ad agency, owner of the billboards that were removed by the city, complained and said that the removal of the billboards amounted to taking of private property without just compensation. Now, I look at this answer. Actually, the state can exercise this power simultaneously, not exclusively or one at a time. So in this particular case, yes, there was taking, but the taking was in the context of police power. The objective, the wisdom of the legislative intent of the ordinance is to remove nuisance boards or obstructions to road signs and traffic signals because they are hazardous. They are they affect the public, the general welfare. And so if police power was used as an implement to enforce eminent domain, then there is no need to pay just compensation. What is the just compensation? It's the fact that the general public, the general welfare was protected or was taken into consideration. There were other bar questions asked along this line. For example, there was one that asked the legal backdrop of the case small landowners on agrarian reform. Now, if we consider agrarian reform, for example, there's a hacienda. Will there be taking of property? Yes, because the huge hacienda will have to be divided. There's taking, and then it will have to be distributed to the landless tillers. Will there be Compensation, yes, the the land bank will determine how much the haciendero will get paid. Um, Now, is it private property? Yes, because it's a hacienda. But as to the other element, is it for public use? Now, what is the consequence of an agrarian award? They actually give a title to the landless tiller. So, is that title private or not? And if it is private, does it satisfy public use? The Supreme Court said that public use can also mean public interest or public welfare. Okay. Now, what is so significant about giving landless tillers a piece of land? If you know historically, the uprisings that happened in the Philippines were a precipitate. The cause is the non-recognition or this people tillers of the soil were not allowed to own land. So there is public interest involved there. And so even if you give titles to a few people who are beneficiaries of agrarian reform, that also translates to public interest. Okay, let's proceed to talk about the power of taxation. Please take note of the lifeblood theory, right? The taxation is actually the lifeblood of government. It is where the government gets money to keep itself running. Now, there was a bar question asked, may a legislative body enact laws to raise revenues in the absence of a constitutional provision granting the said body to tax? Now, I mentioned this a while ago. The truth is, the fundamental powers are inherent powers and may be exercised by the state even without the Constitution. You know that the state has to survive. And how does it survive? First, it has to have property. It has to have land upon which it could build bridges and roads and other infrastructure. Second, there must be a revenue, right? There must be money to pay obligations, to pay personnel, right? And it must be able to regulate behavior under police power. Okay. Under eminent domain, by the way, please do not think that the only thing that can be expropriated are real estate. Okay, not really, because you can also expropriate real property. All right. Even services may be expropriated. So eminent domain is not exclusive to real properties. Okay, moving on to the Legislative Department. In 2017, they asked if there is an exception to the provision saying that before a bill becomes a law, it has to pass through 3 readings on 3 separate days. Now, what I want you to remember here is that it doesn't only require 3 readings, it also requires that the 3 readings be done on 3 separate days. And I would like to remind you of how a bill becomes a law. If it originated in the lower house or in the House of Representatives, 3 readings on 3 separate days, and then it goes to the Senate and it undergoes the same process. It has to be read 3 times and in 3 separate days. Now, is there an exception to this rule? The answer is yes, and it is found in Section 26, Article 6. It says 3 readings on 3 separate days, except when the President certifies to the necessity of its immediate enactment. So this is the thing that you hear when they say it was certified as urgent. And why is it certified as urgent? Because there is a need to meet a public calamity or emergency. So moving on, again, this is something that I think will be asked in the bar, because there is a fairly recent case decided last year, the case involving pharmaceuticals. But anyway, let's look at this 2019 question. It says, a committee of the Senate invited Mr. X and Mr. Y as resource speakers for an inquiry in aid of legislation. Mr. X refused to attend, saying that it is the Senate and not the committee that has the power to compel attendance. Mr. Y attended the committee hearing, but he refused to answer, invoking executive privilege. So the committee insisted that Mr. Y answer the question pursuant to the right of Congress to information from the executive branch. So the call says, based on this argument, is Mr. X's non-appearance permissible? To answer that, we need the black letter law, Section 21, Article 6. It says there that the Senate or the House of Representatives, but look at this one, or any of its respective committees. Now, normally, in their internal rules, there are several committees, and all of these committees can call hearings in aid of legislation. So this is timely, and that's why I think a question will be asked on this topic, because we've been watching a lot of inquiries on TV nowadays. For example, the inquiry on Pogo, the inquiry on even monkeypox and all of that. So, but there is a requirement here. It says that yes, they have the right to conduct inquiries in aid of legislation, but they need to respect the rights of persons appearing in or affected by such inquiries. Now, what could be a topic for a legislation? The answer is any. There are so many things that are that may be a proper topic of legislation, and so it's difficult to object on the basis that it is beyond their authority to legislate. For example, in that case of Lincoln Uy versus the Court of Appeals, they were asking if it is permissible for the committee to be asking even their personal money, even their properties. And the answer to that question is yes, it is relevant, because any expenditure of public money, and they were being accused actually of amassing so much wealth from the COVID response of the government. And because the power to conduct inquiries in aid of legislation is very difficult to limit, the appearance of resource persons may be compelled. The Supreme Court in that case that I just mentioned said that if the Senate or its committees will not be allowed to punish those who refuse to attend, then the right of inquiry will be rendered useless. So the court said they may compel attendance, and if they do not attend, they may be cited for contempt and be arrested. Right, another question. In 2010, the House Committee on Appropriations conducted an inquiry in aid of legislation into the alleged irregularities and anomalous disbursement of the CDF. Now, It says they're implicated in the questionable disbursements for high officials of the palace. So the House summoned X and the DBM secretary to appear. X refused to appear. The secretary appeared but refused to answer, invoking executive privilege. The question is, may X be compelled to appear and testify? And if yes, what sanction may be imposed on him? So, I repeat, they may be compelled to appear because that right of inquiry is in the Constitution. And if they do not like to comply, they may be cited in contempt and punished accordingly. But take note that the only person who can invoke executive privilege is the president or the executive secretary. But even if it is the executive secretary, it still has to be by order of the president. So you may be cited in contempt or ordered arrested if you refuse to comply with the orders of the Senate, the House, or their committees. Okay, here. Again, this is something that could be asked because in relation to the investigations being made by the International Criminal Court or the ICC, they are asking if President Duterte is still immune from suit. So in 2018, they asked this: will the president's immunity from suit continue even after his term has ended, considering that the events covered by the petition took place during his tenure? I said that this could be asked because there were so many cases, for example, that they filed against former President Gloria Arroyo, and they were dismissed, or she was ordered dropped from the suit because the president is immune from suit while he or she is sitting. Okay, but after his or her term, he or she may no longer invoke presidential immunity. Now, of course, if the president is still incumbent, you cannot sue him or her. What is the reason behind that? The law, the Supreme Court said that if the president will be forced to just parry and always try to defend himself or herself, then he will have no more time to take care of the day-to-day operations of government. He will be saddled by all of these suits, and so he or she should be immune while he or she is sitting. Now, how about if their term ends already, and then the answer is they are no longer immune, they may be sued? Question: even for actions that they performed while they were sitting? The answer is yes. Even if the acts were made during their incumbency, they may still be sued and they cannot invoke immunity. Okay, another question. 2022, after martial law was declared over Mindanao, police officers arrested Jose Maria without any warrant. Jose Maria questioned the validity of the arrest, saying that he had no pending case and was not committing any crime. So the police officers countered that the declaration of martial law suspended also the privilege of the writ of habeas corpus. Now, the question is the contention of the police officers correct? So stated otherwise, if the president declares martial law, does it automatically suspend the privilege of the writ of habeas corpus? The answer is found in section 18. It says that the president may call upon the armed forces to suppress lawless violence. And in the second paragraph says he may suspend the privilege of the writ of habeas corpus. Take note, or place the Philippines or any part thereof under martial law, which means to say they do not follow each other. They do not. It doesn't necessarily mean that if he declared martial law, then he also suspended the privilege of the writ of habeas corpus. This is one of my predictions for the coming bar. This was asked in 2008, but it could have been designed for last year or from when President Duterte left office. So the question says, the president alone, without the concurrence of the Senate, abrogated a treaty. So unilateral withdrawal from a treaty. Assume that the other party to the treaty is agreeable to the abrogation. Okay? Then, if a case involving the validity of the treaty or abrogation is brought to the Supreme Court, how should it be resolved? So, stated otherwise, may the president unilaterally withdraw from a treaty? And if he does, is that what should be the ruling if it is brought before the Supreme Court? In the case of Pangilinan versus Cayetano, the ponente said that the president is the architect of all diplomatic and foreign relations. Now, while we're at this, please take note that that all incidents of diplomatic relations pertain to the president, to the executive branch. What do I mean by that? The negotiation, signing, and even the ratification of contracts is lodged before the president, or the executive branch. Sir, even ratification? Yes. If you look at Section 21, it says there that no treaty or international agreement shall be valid and binding unless concurred in. Was the word used? Concurred. Meaning, the president will ratify and then Senate will just concur. Concur means to agree. All right? But ratification is a function of the head of state. Okay? So, the ruling was the president can withdraw from a treaty as a matter of policy if the treaty is unconstitutional or contrary to provisions of an existing prior statute. But the president may not unilaterally withdraw under the two circumstances here when the Senate conditionally concurs and indicates in their concurrence that they should also be consulted. Their concurrence should also be taken if the president intends to withdraw. Then the second one, when the withdrawal itself will be contrary to a statute or to a legislative authority to negotiate or enter into a treaty. What does this mean? Because we are a dualist country, what we do is if there's a good international law, we transform it to our own laws. And if that happens, the president cannot just unilaterally withdraw because there is a domestic law that cannot be repealed by the treaty. Okay? So this case is this question is actually answerable if you have the case of Pangilinan versus Cayetano. Let's go now to the third branch of government, the Judicial Department. In 2004, this question was asked. It says, in the 1935, 73, and 87 Constitution, there's a common provision saying that judicial power shall be vested in one Supreme Court, etc., etc. The question is, what is the effect of the adoption in the 1987 Constitution of the following provision? Judicial power includes the Court of Justice to settle actual controversies involving rights that are legally demandable and enforceable, and to determine whether or not there has been grave abuse of discretion. So, you're being asked what the effect is. So it says, discuss briefly, citing at least one illustrative case. Now, to answer that, we need to define what a political question is and what a justiciable question is. What the power of judicial review, because that's that clause. that says determine whether or not there has been grave abuse of discretion is your power of a judicial review. What it did was to blur the line between political question and justiciable question. Now, take note that this constitution was a reaction to the authoritarian regime before it, and as a result, the framers wanted to prevent the president from claiming that his actions are political questions that may not be taken cognizance of by the court. Now, what the power of judicial review did was to blur the line, like I said, between political question and justiciable question, because now even even if there is a political question involved, the judiciary may still step in to determine whether there was grave abuse of discretion in coming up with that decision. Um, so this power of judicial review is so broad that you can even question internal rules, but not the wisdom of the internal rules, but the manner by which they came up with a decision or judgment. So this question in 2004 is the same. It says SDO was elected congressman. Before the end of his term, he inflicted physical injuries. So later, the House divided party lines and voted to expel him. But this is the clincher. Claiming that his expulsion was railroaded and it was tainted by bribery, he filed a petition to the Supreme Court seeking to reverse that his expulsion. So the question is SDO's petition before the Supreme Court justiciable? Note that the power to discipline members of Congress, of the House, is lodged also exclusively within that chamber. And they have their own internal rules to determine what constitutes disorderly behavior, what constitutes unethical conduct, and so on. So, as a rule, the Supreme Court could not intervene with the suspension of a congressman for disorderly behavior, because that is a function of the House of Representatives. But as in this case, if they are asking if the petition is justiciable, then the answer is yes, because while the determination of what constitutes disorderly behavior is political, while the expulsion is political, the manner by which it was arrived at is justiciable. And in this case, in this question, SDO claimed that his expulsion was railroaded and there was bribery, meaning there is cause to find out if the internal rules of the House was followed or not. Because if it was not followed, then the Supreme Court may step in, the court may step in and say that it is a justiciable question. Very, very basic question in 2009. Define or explain the doctrine of operative facts. Now, what is operative fact? You just remember the word operate, meaning andyan na, it's been done. So the answer is the operative fact recognizes the existence of the law or executive act prior to its declaration of unconstitutionality. Now, it's easy to visualize this. Just think about the legal concept that says that laws, while they are valid and subsisting, will create obligations and also give benefits, right? Now, for example, and this 2009 case is actually a case that was based from the CDF, or the Countryside Development Fund, or even the DAP, Development Acceleration Program of the government during that time. In that instance, there were several monies that were used by the government to build bridges, to build infrastructure. And then subsequently, the Supreme Court said that's not allowed because it should have reverted to the national treasury. Those are not savings, and there is an appropriation, and we must follow appropriations. But in the meantime, there were things constructed already. And so, by virtue of the doctrine of operative facts, we cannot nullify the what was already created when the law was still valid. Okay, so it's prospective. The declaration of unconstitutionality is prospective because of the operative fact doctrine. Okay, now let's go to constitutional commissions. So this is an interesting question asked in 2003. It says a corporation was issued a certificate of incorporation by the SEC, the Securities and Exchange Commission. But it is a GOCC, but it is SEC registered. So the Civil Service Commission, in a memorandum order, directed the corporation to comply with the CSC. The memorandum order was assailed by the corporation, saying that it is not covered because they are SEC registered. They don't have their own charter. So the question is, how should the case be resolved? Now, the black letter law is this: the civil service embraces all branches, subdivisions, instrumentalities, even GOCCs, but only those with original charters. Now, obviously, this corporation in the question does not have an original charter because they were registered under the SEC. All right, SEC registered GOCCs do not have original charters and are therefore not covered. But while we are here in this question already, is the or can the CSC participate in the selection of employees for the judiciary? Or do they have a jurisdiction also over the judiciary? And the answer is yes, because look at Section 2, Paragraph 1. Civil service embraces all branches. There are only 3 branches of government. Okay? So the president, the executive, legislative, and judiciary, they are all covered by the civil service. But as a caveat, the civil service will also govern a personal acquisition, merit and fitness for all employees of the court, salary grades, and so on. But as to administrative discipline, it is lodged exclusively before the Supreme. This next question is trying to test your knowledge of what public funds mean. It says here that Congress established by law an entity known as Philippine Funds Incorporated. And the purpose of establishing that is to receive foreign donations coming from abroad, which are aids during calamities and disasters. Now, the question is, can Congress pass the law that would exempt the foreign grants from the jurisdiction of the COA? So necessarily, we need to know what the jurisdiction of the COA is. And it says here that they have the power, authority, and duty to examine, all revenue and receipts of and expenditures of funds and property owned or held in trust by the government. Now, if you look at the administrative code also, there is a definition there of public funds. And it says that public funds are not only those that are generated through taxes and other revenue generating efforts by the government, but also those that were donated to it in the pursuance of its governmental functions. Okay, so let's proceed to the Bill of Rights. And before we go to the more interesting topics of arrest, search, and seizure, let's talk about due process first. So in 2022, they asked this, says pursuant to a law ordering the fixing of just and reasonable standards, classifications, regulations, practices, or services to be furnished, observed, and imposed by operators of PUV, the LTFRB issued a no car beyond 6 years policy. You cannot use those cars and operate them as a taxi. So the operators questioned that and said that they were not consulted. They were not given notice prior to the issuance of the regulation. So question is, were the taxi operators denied procedural due process? And the answer here is previous notice and hearing, including submission of position papers, are not essential to the validity of general administrative rules or regulation unless the law provides. Now, is this not a violation of procedural due process? The answer is no, because they are trying to assail the issuance. All right. This is different from procedural due process, which happens during administrative investigations. Okay. So that's the short answer. Notice and hearing is not required for the promulgation of subordinate legislation. Okay, in 2010, very basic question. Compare and contrast over breadth doctrine from void for vagueness. I know you memorized that already, but I would like to caution you and please remember that these two doctrines are not just limited to, they're no longer limited to free speech cases. In fact, in Estrada versus Sandigan Bayan, this was used to assist also, no, or to resolve a criminal case, not just a free speech case. Okay, so over breadth simply is there is a law that is too broad in application, such that it encroaches already on protected freedoms. The void for vagueness is even simpler. All you need to do is ask, gets mo ba, or is it understandable for persons with common intelligence. Take note that for void, for vagueness, some flexibility is allowed. A meticulous specificity is not required. Okay. Okay. So let's go to still on equal protection. It says here under Section 6, Article 5 of the VFA, the custody of a U.S. Personnel who becomes subject to criminal prosecution shall be with the U.S. military authorities if he requests. So the constitutionality of that provision is challenged on the ground that it violates Equal Protection Clause because it allows the transfer of the custody of accused to a foreign power which is not afforded to the rest of the Filipinos or other foreigners. So the question is it violative of equal protection? Equal protection simply says that no person or class of persons shall be deprived of the same protection. So you treat persons differently, now, if they're different, but you cannot treat them differently if they are not similarly situated. All you need to have is a valid classification. Okay? And how do you do that? Look for substantial distinctions which make for real differences and not just classification that are arbitrary or unreasonable. So in this case, is this allowed? The answer is yes, because there is definitely a valid classification between a foreigner, a US soldier, and a local or domestic soldier. Still on equal protection, 2015 bar question. The Gay, Bisexual, and Transgender Youth Association wanted to join the forthcoming party list elections. The COMELEC denied it because they reasoned out that that organization espouses immorality. So JBTYA challenges the denial of the application and says that it is violative of the right to equal protection. So there are two questions. First one is, what are the three levels of tests that are applied in equal protection cases? And then the second question is, which of the three levels of tests should be applied to the present case? Now, this is where you answer, you put these three tests. So it's just visualize it, imagine it as like a small, medium, and large. Rational basis is the most lenient test because it presumes constitutionality, whereas the second scrutiny is medium, intermediate. There is heightened scrutiny, but it doesn't really involve fundamental rights. And then the last one is the strict scrutiny, because the assailed law already interferes with fundamental and basic liberties. Now, what I want you to note here is there are what is known as suspect classification. Now, what falls under the category suspect classification are the following. First, you have, of course, race, you have nationality, and religion. So, if the action of government infringes or involves suspect classification, race, nationality, and religion, then you apply the strict scrutiny test. What is the meaning of basic liberties? It's of course life, liberty, and property. Those are the fundamental rights. But then, for intermediate scrutiny, there is a concept known as quasi-suspect only. So if it is quasi-suspect, it is not race, nationality, or religion, but gender and legitimacy. So that's the answer to the second question. What type of test should be applied? Because it involves gay, bisexual, and transgender youth, then it is a quasi-suspect subject matter. We apply the intermediate scrutiny test. All right. There is a case where the Supreme Court ruled on equal protection clause, the case of Albano versus Comelec, and that involves the question whether the right to run for election is a right or a privilege, and the court there went on to distinguish who are or the difference between those who lost in the last election and those who did not. Okay, so you apply the rational basis review there only because there is no race, nationality, or religion involved, and neither is there gender and legitimacy involved in that case. Okay, on to arrests, searches, and seizures. So the first question we have here is a passenger bus conductor saw a bag that was left in the bus. So he got curious and he wanted to know who owned it. So he opened it up and found a calling card with the owner's name, Dante Galang. But he went on to investigate further and found a sachet of a white powdery substance. So he brought that thing to the NBI, and the NBI determined that it was shabu. So Dante Galang was subsequently traced and found, and he was brought to the NBI office where he admitted ownership of the handbag and its contents. So in the course of interrogation, he was made to sign a receipt, etc., etc. And he was forthwith charged with illegal possession of drugs and was convicted. So on appeal, he says that the plastic bag and its contents are inadmissible because they are the product of an illegal search and seizure. Now, obviously, okay, the answer to this question is the the concept saying that the constitutional prescriptions against, and even the Bill of Rights, most of the Bill of Rights are only you may only invoke them as against the government. Take note that the Bill of Rights were put there by the sovereign Filipino people to prevent abuses from the government. So the Bill of Rights, including the rules on arrest, searches, and seizures, are extended only, may be invoked only against the state. In this particular example, the bus conductor is not an agent of the state, and therefore the exclusionary rule will not apply. But before we proceed any further to your other examples on arrest, search, and seizure, I want us to go back to Section 2 of Article 3, and this is where the entire the whole topic of arrest and seizure was encapsulated. So I highlighted a few words here. This is the general rule. This is how you should think about questions on arrests and seizures. The general rule is you have the right to be secure in your person, meaning if you're not doing anything bad, if you're not committing a crime, will commit a crime, and so on, then the police, the agents of the state have no business arresting you. Okay? It is inviolable. The exception to this is when they have a warrant of arrest. Okay? Think about it that way. That's why if you read Supreme Court decisions on this matter, they would first start by describing what that person was doing when he got arrested. So we have several examples. For example, there was a person who was sitting on a jeepney. And in another case, there's this person sitting on the edge of a bed. There's a person walking, crossing a pedestrian lane. So the Supreme Court goes on and tries to explain first what the person was doing. Okay? Because that's what you need to do also. If there's a question on arrest and seizure, first look for it in the facts. What is this person doing? Now, if he's not doing anything, then they should not be arresting him, except if they have a warrant of arrest. Okay? But there are also exceptions to the exception. In Section 5, Rule 113, you can find 3 exceptions when you can be arrested even without a warrant. And you should know this already by heart. Okay? In flagrante delicto simply means that you were caught, right? Flagrante is a fire, right? So, mainit-init pa, smoking gun, so to speak, right? So, in his presence is the clincher here. Okay, he must be there. He must be present. For hot pursuit, in the on the other hand, um, all that is required is for you to have a personal knowledge. Okay, but take note of the time element here. The words used are has, just, been. Okay, so immediacy and the time element is important. Then, of course, the last one is if you're a fugitive, then you may be arrested without a warrant. Same is true with search and seizure. So I highlighted again the words here. The right of the people against unreasonable searches and seizures is inviolable, except if there is a search warrant. Okay? Now, this is the exclusionary rule. Any evidence obtained in violation of that will be inadmissible. And take note, in any proceeding, not just in criminal proceedings, but also administrative cases, even labor cases. Okay? Because it says in any proceeding. Okay? So, like in arrests, there are also exceptions to the exception when you may be searched you may be searched without warrant. The first one is customs searches. The idea here is time is of the essence, and so if they still need, if the law will still require them to go to a judge, then it might be too late because you would have exited already, or left. Same is true with the checkpoints. Because they are mobile, there is no need to secure a search warrant. Okay, you can do a visual inspection during checkpoints. Number three, plain view. What's important here is they must see the item without doing other things, and the item must be illegal, right? In consent searches, the Supreme Court said that this is difficult to prove because they noted that people are afraid of law enforcement people, and so the burden shifts to the police to show that consent was really given. And then number five, look at the sequence of this. You must first be lawfully arrested, either with a warrant or warrantless arrest, before they can subject you to a warrantless search. And then in relation to that, also number six, stop and frisk or Terry searches. This happens when the police officers would pat you and inspect your outer clothing to determine if you have weapons or anything that could hurt the public or the arresting officers. Now, this 2022 bar question is about a person who was caught urinating in public. The ordinance imposes a fine for urinating in public. So Harvey was caught urinating in public, and then when he was accosted by the police, they found an unlicensed firearm with live ammunition. So he was charged with qualified illegal possession of firearms. When the prosecution attempted to introduce the evidence, it was objected to by Harvey, saying that it is the product of an illegal search and seizure. The prosecution, on the other hand, said that they were lawfully seized because a valid warrantless arrest was effected, and so he may be searched without a warrant. Okay? Question is, was the search and seizure valid? The answer is in, of course, the enumeration of when an arrest may be done without a warrant. So here, is Harvey under arrest? I think that's the first question that we need to ask. Is he under arrest? And the Supreme Court in one case said that if the infraction is punishable only by a fine, then he is not under arrest, right? So when he was urinating in public, he could not have been under arrest, and therefore there could be no search incidental to a lawful arrest. Okay, let's do another one. Still on arrest, searches, and seizures. So this question says that Ernesto was a minor. He was driving a car which was stopped at a mobile checkpoint. SPO1 Jojo noticed that Ernesto was a minor. I don't know how. And so he asked Ernesto to exhibit his driver's license, but Ernesto failed to produce it. So SPO1 Jojo asked Ernesto to alight from the vehicle, and when he complied, the police officer saw a bulge in the pants of Ernesto, and so he frisked him and found an unlicensed firearm. Ernesto was arrested, detained, and charged. But at the trial, Ernesto questioned the manner by which he was arrested, because he says in a checkpoint only visual search is allowed, and he was not supposed to have been directed to alight from the vehicle. And so the lawyer for Ernesto said that the search was illegal, and therefore the gun that was seized may not be used in evidence. That is true. His argument is correct. In checkpoints, they are limited to do a visual search, and the occupants cannot be subjected to a body search, right? Take note also that in checkpoints, the police officer cannot extend his hand and reach anything inside the car. All they can do is visually search, right? They cannot ask you to open any compartment or open bags inside the car, right? And definitely, you are not required to alight from the vehicle. So let's go back. So is this a search incidental to a lawful arrest? Is Ernesto under arrest? So again, similar with the previous question, he was not under arrest. So at best, he would have been fined. Okay, so the evidence obtained is also excluded because it is not a search incidental to a lawful arrest. Okay. The Supreme Court made this enumeration, and please go back to your case, the Sapla versus People case, because you'll be able to get a lot from there. Okay, here the Supreme Court discussed when when the arresting officer may proceed to make an arrest. Okay, the court said there should be at least two or more suspicious circumstances. Now take note that there are several kinds of probable cause. The first one is probable cause for a judge to issue warrant or search. And then there's a probable cause on the part of the prosecutor to file a case in court. And then there's probable cause for law enforcement officers. Okay? So here, we will see that in these cases, there were more than two. Okay? Or at least two suspicious circumstances. In Manalili, the person who was arrested was found in a cemetery that is a known area where illicit activities are being done. And coupled with that, he was also wobbling, like he was drunk, and his eyes were red. So, because of this, the police had probable cause to believe that he might be doing something illegal. That's why they accosted him and made the arrest. In People versus Solayao, the accused and his companions were making drunken actuations. And then when his companions saw the police, they ran. Now, were the police supposed to be there? The answer is yes, because they were on a legitimate mission to verify reports that armed persons were roaming the vicinity. In Palencia versus People, the accused was checking out some plastic sachets, and then when he saw the police, he ran. And where he was found, the area is known for the trade of dangerous drugs. So in all of these instances, take note that this aggregate of circumstances gave the police officer probable cause, okay, to effect an arrest. Okay, we answered this already, Ernesto. The basis of the arrest here was the discovery of the unlicensed firearm. But since the search was invalid, the warrantless arrest was likewise invalid. In the first place, he should not have been asked to alight from the vehicle. So if he didn't go down the vehicle, they would not have seen the bulge in his pants, and the weapon could not have been discovered. Okay, 2009 bar. Witnessed two hooded men with baseball bats. Then he heard B, his neighbor, saying, "Wag pilo, babayaran kita agad." And then he saw the two hooded men hitting B until he fell lifeless. Then the assailants escaped using a yellow motorcycle with a fireball sticker. So they reported it to the police. The following day, the police saw the motorcycle parked in the garage of a house, and he inquired with the caretaker, and the caretaker said, "Oh, that's owned by the brothers Pilo and Ramon." And he said that they were outside of the country. So PO1 Noval insisted in getting inside the garage, and when the caretaker, out of fear, allowed him in, he took the two ski masks and two bats beside the motorcycle. Question is, was the search valid? And what about the seizure? Okay. Now we go back to the instances when warrantless search is valid. So is there anything here that would justify it? The answer is no. Why? Think about hot pursuit. Is this still hot pursuit? And the answer is no more, because actually they relied on a mere tip, from a witness. Okay, and what they should have done was to secure a search warrant. Okay. And also when they took the ski masks and the bats, that was illegal because they cannot justify that as a plain view exception. Also, the waiver could not have been given by the caretaker, because waiver is only allowed or you only allow the person involved to waive it. Okay, warrantless seizure is not justified under the plain view doctrine. I said that already. All right, we illustrated this already briefly in 2009. they asked this question. So it says crack officers of the anti-narcotics unit were doing a surveillance, and then they saw a man with reddish and glassy eyes. He was walking unsteadily like he was drunk. And then when he saw the policeman, he veered away. So the police approached him. It gave them probable cause already because of, two or more suspicious activity. When he asked him what he had clenched in his fist, he did not say anything, and so the policeman pried his hand open and saw shabu. So he was charged in court, but he objected to the admissibility of the evidence because he reasoned out that it was a result of an illegal search and seizure. Now, this is an application of your stop and frisk rule. And again, there is an application here of probable cause on the part of the law enforcement officers. Since the accused had red eyes, he was walking unsteadily, and he was in a known hangout for drug addicts, the police had sufficient reason, probable cause, to stop the accused and to frisk him. All right, this is another question on the, warrantless seizure. Okay, so this is a case of carnapping, and when the car got stolen, the driver used an app called Find My Car. So it's a GPS tracker, and then when he was able to locate it, he reported it to the police. Now, take note when a question has very specific data there, for example, or information. For example, in this case, they indicated that 6 hours after the car had been stolen, you see, so that's very material, and it seems to point us to an answer, a suggested answer. So 6 hours after the carnapping, the police, armed with the information from the GPS tracker, went to a private home and saw that the car together with other stolen cars were inside the house. And so what they did was they arrested the owner of the private home, and he got charged with carnapping. So question is, are the seized cars admissible in evidence? So this is his arrest, okay? So is his arrest valid in the first place? This question is similar to a new case, the case of Adoma versus People. And there, the Supreme Court said that for a valid arrest effected in hot pursuit, they must be able to show that they have personal knowledge of facts, which is based on their observation. When you say based on their observation, then it must be with the use of their senses, right? The hot pursuit is done because a crime has just been committed. And therefore, the element of immediacy from when the crime is committed up to the point of arrest is very material. All right, so in this case, was the person validly arrested? The answer is no, because they did not have any reason to not get a warrant of arrest. Take note that they relied on a mere tip, an information coming from the complainant. And if we go back to the Sapla case, the court said that information alone, no matter how, even if it comes from a credible source, is insufficient. okay, to establish probable cause to effect a valid warrantless arrest. In the case of Adoma, what happened there was something similar. Um, this person at 6 a.m. Got robbed, so they stole his laptops, iPad, cash, watch, and he immediately reported that incident to the police. So the police entered it into a blotter, and then he realized that he could track his laptops using a phone app, and so he did. And then he went back to the police station and told them that he found the articles. He knows where they are. So the police created a team and they went to that house. When they arrived there, they saw the items being unlocked by a person. So they asked him why he was in possession of those gadgets, and he said somebody, Adoma, um, is just requesting him to unlock the gadgets. So the police told him, okay, when he calls, you have to tell him that you're done with the job that he wanted you to do, and then we'll take it from there. So coincidentally, the Adoma called that person, the repairman, while he was still in the police station, and then the police station said, "Okay, just tell him they're ready. The items are ready." So they went back to the house. They planned to arrest Adoma. So as soon as money exchanged hands, they arrested Adoma. So is that a valid hot pursuit warrantless arrest? The Supreme Court said no, because there was a lapse of a considerable amount of time from the happening of the crime to the arrest. And not only that, the court also said that the information, even coming from the person who lost the items, is not enough on its own for the police to have, probable cause to effect a warrantless arrest. Okay, free exercise. Um, they want you to distinguish between free exercise of religion and non-establishment. Now, this is quite easy, because all you need to do is these are clauses, and they're found in Section 5. So, for example, the non-establishment clause says no law shall be made respecting an establishment of religion, and then the free exercise clause is or prohibiting the free exercise thereof. But I think the more important elements here are under free exercise, you have two rights: the right to believe and the right to act on your belief. The right to believe is in the sphere of the mind, and so it is absolute, no matter how immoral or dangerous your thoughts are. There's they cannot intrude into that. You have the absolute right to think about all of those, to believe. But the second one, the right to act on one's belief, is regulated, because that is the one that has an effect, or could cause an effect with the rest of the community. And then, of course, non-establishment is simply the prohibition for the state to spend, to set up a church, to aid one religion, all religions, or prefer one religion over the other. I don't know if you remember the case of Mr. Celdran, where he went inside the church, and he had with him a placard. Okay, he has the right to believe, but what he did was actually a violation of not only the right also of the priests, but there is a crime punishing offending religious beliefs. So that's what happened to him. Right to believe absolute, but you cannot act on that belief if it will affect or prejudice the rights of other people. Uh, okay, let's go to another right, the liberty of abode. Juan Casanova contracted leprosy. His wife wrote a letter to the city health office and asked that he be isolated in a leprosarium. So Juan Casanova challenged the constitutionality of the law, saying that it is violative of his liberty of abode. Now, there could be a question similar to this in this coming bar, but maybe they will frame it and use an example or a set of facts that could have happened during the pandemic, because it's similar. If you had COVID before, you will be put in a quarantine, an isolation facility. So, is this violative of his liberty of abode? The first thing you need to remember is liberty of abode is not absolute. And because leprosy is highly contagious, then the general welfare must prevail in the exercise of the state's police power. Um, the state should be able to exclude you from the community so that it will not create an epidemic. So the answer is the same if it's COVID. A lot of people were complaining before why, if they get infected, or if they get sick of COVID, they will be taken out of their homes and placed in quarantine facilities. That is perfectly legal because police power is a very broad and plenary power that is being exercised by the state for the general welfare. Okay, let's discuss eminent domain. But before I proceed to this 1994 bar question, um, I would like you to remember that what can be expropriated, or the subject of eminent domain, is not only real estate. You can expropriate properties and even services, right? So this question says that the municipality already expropriated the property and allocated 1 million for the purchase of that lot. But then when the case was filed in court, the court fixed the value at 2 million. So there is a variance. Now the question is, what legal action can Juan Reyes take to collect the balance, and can Juan Reyes ask the RTC to garnish the municipality's account with the land bank? The answer there is yes. Patrimonial properties may be levied, but if there are no patrimonial properties, a petition for mandamus may be resorted to. Municipal funds may even be garnished, but only up to the amount already appropriated. So in this case, there was already an amount appropriated, earmarked for that purpose, the 1 million pesos. So it ceases to become a restricted deposit, so you can garnish that already. Okay. But let me modify this question just to exercise our brains. Let's say the municipality of Antipolo offered to buy the property for 1.5 million pesos. And then the private owner agreed to that price and wanted to sell it for 1.5 million. My question is, do they still need to file a case of eminent domain? The answer is no more. Eminent domain is a fundamental power of the state to compel a person to sell. And if there was already an agreement, a meeting of the minds, that the government, the municipality will buy and the private owner will sell, all that is needed to be executed is a deed of sale. There is no more need to go through the entire process of eminent domain. Hello again. Let's continue with the citizenship. This bar question asked in 2006 was about a lawyer who was born out of a Chinese father and a Filipino mother. But every time that you see questions on citizenship, I want you to look at the date, because the date will be your basis to know whether you will apply the 1935 Constitution, 1973 Constitution, and the 1987 Constitution. So this particular example will definitely use the 1935 Constitution because he was born in 1964. Now, the 1935 Constitution says that if your father is a Filipino, then you're a Filipino. But if your mother is a foreigner, then you need to elect Philippine citizenship when you reach the age of majority. Now, this bar question says that he is the son of a Chinese father and a Filipino mother. But it also says that the father became naturalized when Attorney Chua was still a minor. Now, the question here is, will Attorney Chua be disbarred because he is not a Filipino citizen? So to answer this question, we need to know what derivative naturalization is. Yes, it's true that his father was a Chinese person, and because he did not elect Philippine citizenship when he reached the age of majority, it seems to point out that he is not Filipino. But in this same set of facts, they also said that his father became naturalized when he was still a minor. So derivative naturalization will benefit Attorney Chua here, because the minor children of persons naturalized who have been born in the Philippines shall be considered citizens of the Philippines. And therefore, there was even no need for Attorney Chua to elect Philippine citizenship, because the naturalization of his father was beneficial to him too. All right, the next question is still on citizenship, and it talks about a person who took up permanent residency in the US. He eventually became an American citizen, got married to an American, and had children. In August 2009, he decided to visit the Philippines with his family. So while in the Philippines, a friend told him that he could reacquire Philippine citizenship without losing his US nationality. So he took the oath of allegiance required under RA 9225. So there are three questions here. The first one says, having reacquired Philippine citizenship, is Warlito a natural-born or a naturalized Filipino citizen? Now, if you look at the law, it says that your repatriation will result in the recovery of your original nationality. So the answer is yes. He reacquires his natural-born status. Second question is, with Warlito having regained Philippine citizenship, will Shirley, the wife, also become a Filipino citizen? And if not, what could Shirley do to acquire Philippine citizenship? So the answer to that question is, it doesn't extend to the wife, but because he is again a Filipino, the wife may apply for naturalization. And then the last question, do the children also acquire his Philippine citizenship? Now, the law says only the unmarried children below 18 years shall benefit from the repatriation. So only Luisa, in this set of facts, will benefit from the repatriation of Warlito. Okay, Judge Red is the executive judge of Green City. Red is known to have corrupt tendencies and has a reputation widely known among practicing lawyers for accepting bribes. So Ombudsman Gray, wishing to clean up the government, initiated an investigation on the alleged irregularities. Judge Red refused to comply and recognize the authority of the Ombudsman, saying that any administrative action against him or any court official or employee falls under the exclusive jurisdiction of the Supreme Court. You're asked to decide with reasons. Judge Red is correct. The Supreme Court has administrative supervision over all courts, meaning from the highest officers, which who are the judges, up to the utility workers and other employees. But I would like to point out that the judiciary is also covered by the Civil Service Commission insofar as hiring, merit and fitness, salary grades, but they are exempt from the administrative jurisdiction of the CSC because, as I mentioned, the power to discipline any officer of the court is lodged exclusively with the Supreme Court. This question is also one of the frequently asked questions in the bar. So in 2019, they asked this question. It says, W is an incumbent congressman who decided to run for governor, but he did not quit his post as governor after he filed his certificate of candidacy. He had been attending plenary sessions and committee hearings in the House. So one of his fiercest critics, X, said that he should not be dispensing the functions of a congressman because he is deemed ipso facto resigned. So the call of the question is X's argument correct? The answer to that is no, because elective officials are not deemed resigned when they filed their certificate of candidacy. Follow-up question says, will it be different if instead of being an elected official, he is an incumbent undersecretary of the Department of National Defense? In that case, persons holding public appointed office or position shall be considered ipso facto resigned from office. And the wisdom behind that is quite simple. If you were elected, then you were given the trust by the electorate to finish that until the next elections. It's different from incumbent appointed persons or officials because there is a danger that you will be using government funds to in your campaign. That's why they are deemed resigned from office so that they cannot have undue advantage because of their position. This 2012 question is about premature campaigning. Mayor Pink is eyeing re-election in the next mayoralty race, and it's well known, it's common knowledge that Mayor Pink will run for re-election. So the deadline for the filing of COC is March 23, and campaign commences the following day. But 1 month before the deadline, Mayor Pink has yet to file her COC. But she has been going around town giving away sacks with the words, sacks of rice with the words, mahal tayo ni Mayor Pink. Therefore, Mr. Green, who is a political opponent, questioned this. In April, noticing that Mayor Pink had gained advantage over him because of her activities, he filed a petition to disqualify Mayor Pink for allegedly prematurely campaigning. So the question is rule on the petition. Now let's look at premature campaigning. Is there such a thing? To be liable for premature campaigning, the candidate must have filed his certificate of candidacy. Now, if you look at the question, it says there that before filing her COC, that's when she went around and distributed those things. So it appears that she was not doing premature campaigning because he was not yet a candidate. So in a case decided by the Supreme Court, they said that in order for you to commit premature campaigning, the offense of premature campaigning, that person must already be a candidate. And in this particular case, while she is the incumbent mayor, she is not yet a candidate for the mayoralty position. Okay, local government. R was elected as municipal councilor for 3 consecutive terms, but before the end of his term, Vice Mayor S died. So the post was vacant. Since R was the highest ranking official, municipal official, he assumed the office of the Vice Mayor. One of his constituents assailed his assumption of office, saying that elections should have been conducted to fill the vacancy. The question is this contention correct? And the answer is no, because in case of permanent vacancy, then the highest ranking Sangguniang shall become vice mayor by operation of law. Okay, so it follows as a matter of law. There is no need to conduct a special election for that purpose. Okay. Still on local government, on August 8, 2008, the governor of Bohol died, and Vice Mayor Cesar succeeded him by operation of law. Accordingly, Benito, the highest-ranking member of the Sangguniang Panlalawigan, was elevated to the position of Vice Mayor. So by his elevation, a vacancy was created. So the question is, how should the vacancy be filled? And the answer is, the President through the Executive Secretary shall appoint, okay, but he may do so only from among the nominees of the political party under which the Sangguniang member concerned had been elected. Okay, now why is that the case? In order to maintain the balance of representation in the Sangguniang. Still in public international law, the question in 2012 was, what are the sources of obligation in international law? Now, the answer to this can be found in Article 38 of the ICJ Charter. The first one in the list are international conventions, otherwise known as conventional international law. Now, when we say general or particular, we simply refer to either treaty or convention. Particular international conventions are between a few parties. We call it usually treaty. Then if there are a lot of parties to that agreement, then it's a convention. Now that is in the hierarchy of if we will assign a hierarchy of sources of obligation, this takes a top place aside from, of course, jus cogens, because you know that the most important element of a contract is consent. So if we relate this the conventions and treaties, if we relate them to domestic law, these are your contracts. And what do we say about contracts? Contracts are the laws between the parties. So this is definitely a good source of obligation, because when countries sign and ratify contracts, they are expressing their consent to be bound by it. The second in the enumeration is international custom. Now you know that there are two elements of customs. The first one is the material factor or the general practice. And then the second element is opinio juris, or the subjective factor. Now, the first element, the general practice or the material factor, is the custom itself, the one that you continued doing, the custom itself. And then opinio juris is a feeling or a belief on the part of the state that they are bound by the law in question. And then the third in the Article 38 list are general principles of international law. Now, remember that under the 1987 Constitution, this is the one that we adopted, generally accepted principles of international law. What are these? These are laws that are norms even that are regarded as universally good or universally right. Therefore, actually, for number 3, you don't need to write it down because as general principles, most peace-loving states know this and they abide by it. And the last in the enumeration may be divided into two. Some authors divide this and say that number 4 is actually in the category of secondary sources. So 1, 2, 3 are primary sources and the number 4 secondary sources. So the fourth source is judicial decisions. Now, does it have to be an international court? The answer is no, for as long as it creates an international obligation. And then the last in the list is the teachings, the teachings of the most highly qualified publicists. So even if there are no international legislations, even if there are no international Congress or Senate, there are sources of public international law. They are not enacted, but they come from these 5 sources. So I mentioned a while ago that there are 2 elements of customary international law. The first one is material factor and the second is opinio juris. This question in 2010 talks about a president who was a dictator whose government was toppled by a combined force led by a General Abe. So the new government constituted a Truth and Reconciliation Commission to look into the crimes committed under the reign of President A. Now, after the hearings, the commission found that there were mass killings, genocide, but they recommended that an amnesty law be passed to cover even those involved in the mass killings. So an international human rights group argued that the proposed amnesty law is contrary to international law. You are being required to decide on that. Is it contrary to international law? Take note that genocide is an erga omnes. What is erga omnes? Erga omnes simply means that these are acts that are globally recognized as wrong. Okay? The opposite or the correlative concept is a jus cogens norm, okay, which punishes erga omnes acts. So the international norm for the prevention, prosecution, and punishment of genocide has attained jus cogens status, and therefore it's non-derogable. So if that country, if the Republic of Gordon will pass an amnesty law disregarding the genocide that happened, then it will definitely violate a jus cogens norm because genocide is an erga omnes. What other things, what other examples can we give to illustrate erga omnes? Piracy has been regarded as erga omnes, and therefore any and all countries will have jurisdiction to run after pirates. Mass murders, genocides, and so on, they are erga omnes. This 2017 bar is about pacta sunt servanda and rebus sic stantibus. So it says State A and State B entered into a 10-year mutual defense treaty, but after 5 years, State A finds that the more progressive State B did not go to the aid of State A when it was threatened by State C. State B reasoned that it had to be prudent and deliberate in reacting to State C because of their existing trade treaties. So the first question is, what is the difference between the principles of pacta sunt servanda and rebus sic stantibus? And then the second question is, are the principles of pacta sunt servanda and rebus sic stantibus relevant in the treaty relations between State A and B? And how about in the treaty relations between State B and State C? So, in order to understand these two concepts, you need to read them together. When I say read them together, it should be pacta sunt servanda rebus sic stantibus. Why? Because the literal translation goes, agreements must be kept, things thus standing. When you say pacta sunt servanda, pacta is agreement, servanda is a connotation of sacrifice. So, it simply means that you have to abide by treaty obligations in good faith, no matter how hard it is, because of the servanda part. But things thus standing. So if there is a change, a substantial change in the circumstances, that change must not only be unforeseen, but it is also unforeseeable. Definitely, the party invoking it must not have contributed to the happening of that change in circumstances. So, is it applicable in this case, the treaty relation between State and B? Yes, pacta sunt servanda. Even the agreement between State B and C as to their trade treaty, it is also applicable because, as mentioned, you have to abide by your obligations in good faith, no matter how hard it is, except you can invoke rebus sic stantibus to terminate your treaty obligations because of a substantial change in the circumstances. Now, in this case, when State B asked to opt out of its treaty with State A and B, was it reasonable? And the answer is yes, because there was a change in circumstances. State B and C had an agreement to deal with each other and enter into a trade treaty. This next question will require you to distinguish between an executive agreement, an international agreement, or a treaty. Now, it's easy to distinguish them because when we talk about treaties or conventions, there are certain formalities that have to be complied with, and they need to be ratified. In the case of executive agreements, there is no need to ratify them because they cover more or less not as broad as a subject as you would have for treaties. But in your bar syllabus, Section 21, Article 7 was specifically mentioned. And it says there, no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. Now, I always ask this because a lot of candidates are still confused what it means when you say concur and to ratify. Fortunately, the Supreme Court already ruled that all the incidents of diplomatic relations and foreign relations are lodged before the office of the president or the president himself. And therefore, from negotiation to signing to ratification, they are all lodged within the office of the president. Now, what does concurred in mean? It simply means that ratification was already done and what is left to do is for Senate to agree to it or not. That's the meaning of concur. And so I want that to be clear, because some candidates still say that to answer the question who ratifies treaties, they say it's Senate. It is not. It is the head of state that ratifies a treaty. It just so happened that in the Philippines, as a safeguard, as a means by which we can give effect to the what do you call that, checks and balances, we required, okay, the sovereign Filipino people required concurrence by at least 2/3 of all the members of the Senate. An executive agreement is less formal. It is not a treaty, and therefore there is no requirement for Senate concurrence. Okay, still on that topic, 2008 bar, but I think this will be asked in this coming bar because of the issue that was created when President Duterte unilaterally withdrew from the International Criminal Court. So the question goes, President alone without the concurrence of Senate abrogated the treaty. Assume that the other country agreed to the abrogation. If a case involving the validity of the treaty abrogation is brought to the Supreme Court, how should it be resolved? The good thing for us is there is a relatively new case decided just last year, the case of Pangilinan versus Cayetano. And this is where, as I was explaining a while ago, this is where the ponente said that the president is the chief architect of diplomatic relations, and therefore the president can withdraw from a treaty as a matter of policy. More so, if the treaty is unconstitutional or contrary to provisions of an existing prior statute. But there are also exceptions to that rule. So the first one is, he may not unilaterally withdraw when the Senate made a conditional or concurred conditionally before, and in that conditional agreement, it required the president to seek their concurrence again if he will withdraw. And then the second is when the withdrawal itself will be contrary to a statute or to an existing law. Okay? And so this Pangilinan versus Cayetano, if you have time, you just go back and read it. This is where they questioned the unilateral withdrawal from the International Criminal Court. But the Supreme Court in that case said that that issue has become moot and academic because our withdrawal was already accepted by the Secretary General, by the United Nations. But as an exception to the moot and academic principle, the court still went on to decide it because it will guide the bench and the bar, and this is something that is susceptible to repetition. Okay, this one talks about Philippine, the territory and jurisdiction. So it says William is a private citizen, and while inside the U.S. Embassy, he got into an argument with a private Filipino citizen, and he killed him. So the question here is the embassy still part of Philippine territory, and therefore, if it is not a part of the Philippine territory, as argued by William, then he cannot be prosecuted here. So the answer there is yes, the embassy is part of Philippine territory because we know already that under the archipelagic doctrine, all islands and all waters surrounding those islands, when you connect a straight baseline enclosing all of them, they form part of a single unit, and that is the territory. But take note that jurisdiction is different from territory. While the U.S. Embassy is still within Philippine territory, under the Vienna Convention on Diplomatic Relations, the premises of the embassy is inviolable. Take note also, and maybe if they will revise this question, they will indicate that the perpetrator is a diplomat. In such a case, we cannot take jurisdiction over the diplomat because, as you know, under the VCDR also, there are certain diplomatic immunities. More so if he is the ambassador. The ambassador is immune from local jurisdiction. And then here, questions on the KIG or the Kalayaan Island Group and the Spratlys. So in 2016, this was asked. Section 2 of RA 9522 declared the KIG as regime of islands. Professor Agaton says that since the law did not enclose the islands, we lost our sovereignty and jurisdiction over them. You're being asked if the contention is correct. To answer this question, you need to know what regime of islands means. So it simply refers to the rule saying that only islands may generate maritime zones, such as a territorial sea, contiguous zone, or an exclusive economic zone. Now, when Section 2 of RA 9522 declared the KIG and Scarborough as regime of islands, that actually is more more advantageous for the Philippines. Why did I say that? Because they will be able to generate their own maritime zones and it will definitely increase our territory. But remember, in the case of Philippines versus China, which was decided by the Permanent Court of Arbitration, they said that those islands in the Spratlys are not islands and therefore may not be considered under a regime of islands. They defined islands as those that are visible during high tide and are capable of supporting long-term human habitation. Okay? And since those rocks and reefs in the Kalayaan Island Group are not really islands, they may not be considered as generating their own maritime zone. So, the contention of Professor Agaton is wrong. In fact, if Section 2 will be followed, then we would have gained more territory because those islands individually will generate their own maritime zones. Okay, in 2004, this question, distinguish territorial sea and internal waters. So you know that territorial sea is that expanse, no? Which is reckoned from the baseline. So you measure 12 nautical miles from the baseline. That is your territorial sea. And up to that point, you have sovereignty. You have the ability to enforce your criminal, civil, and administrative jurisdiction. On the other hand, internal waters are those that are enclosed by the baselines. So they are the waters around, between, and connecting the islands. Okay. So that's the difference between territorial sea and internal waters. But both of them are considered part of the state's territory. 2022 bar, a foreign commercial ship was spotted by the PCG dumping garbage and toxic waste 20 nautical miles from Nasugbo. Now, friends, when you are given a question like this and there are figures, please take note of those numbers. So in this case, it says 20 nautical miles. Now, right off, you should know that this question will be asking you about maritime zones. So the officers of the ship were arrested and charged with the RTC of Batangas for violation of environmental laws. The officers of the ship moved to dismiss on the ground that Philippine courts do not have territorial jurisdiction over the case. So you're being asked if the ground to dismiss is correct. Okay? Now this is where you will use the answer and explain what protective jurisdiction means. So, protective jurisdiction is the sovereign right of a state to prevent or punish violations of its customs, fiscal, immigration or sanitary laws and regulations. And this extends up to 24 nautical miles. Or this protective jurisdiction is available to countries reckoned from the end of its territorial sea up to another 12 nautical miles. So, or from the baseline plus 24 nautical miles. Okay? So you have protective jurisdiction over that area. Now, obviously, the dumping of toxic waste is in violation of sanitary laws and regulations. In this case, the Philippines can exercise protective jurisdiction and punish the wrongdoers. 2007 bar. It says Lawrence is a Filipino computer expert based in Manila, and he invented a virus that destroys all the files stored in a computer. Assume that in May 2005, the virus spread globally and caused $50 million in damage in the United States alone. That in June 2005, he was criminally charged before the U.S. courts under their anti-hacker law. And then a month after, in July 2005, the Philippines adopted its own anti-hacker law. Okay? So the U.S. requested the Philippines to extradite Lawrence because we have an extradition treaty. Call of the question, is the Philippines under an obligation to extradite Lawrence? State the applicable rule and its rationale. So there are two topics that are always asked when we talk about extradition. That is speciality and double criminality. In order for the extradition treaty to be validly or successfully invoked, these two conditions must be present. So the first one is the extradited individual will only stand trial for offenses that are specified in the extradition. And right off, you will see here that when the offense was committed, there was no anti-hacker law yet in the Philippines, because the virus was spread in May 2005, and the Philippines only enacted legislation against hacking in July 2005. So, you apply the concept nullum crimen nulla pines sine lege, and therefore he cannot be extradited because the first requirement is not present. And then the second requirement, an extraditable offense must be an offense that is punishable under the laws of both the requesting and the requested state. Now, this means that there must be a corresponding law also in the other country. My example here is, for example, in the Philippines, we have murder, you have homicide, and then you have reckless imprudence. And then in the US, you have first-degree murder, second-degree, and then manslaughter. So manslaughter seems like, or is similar to our reckless imprudence. So they don't have to have the same name for as long as it punishes the same act. Like, let's say rape. Rape is a generic term. But in the Philippines, rape may be committed also by sexual assault. So it doesn't have to have the same name, but for as long as it punishes the same act. Okay, I think that's we'll end there. And I wish you luck. Don't forget to pray. It works. Just relax. You've done your part. And you leave the rest to God. Thank you very much, and God bless you all.
Thank you so much for the insightful lecture, Attorney Libiran. Our online viewers will surely be equipped with the lectures they need for political and public international law. For this part of our program, we have some questions for you, Attorney. Number 1. Bar candidates would usually isolate themselves during review period, which means that they have limited to no access to current events. would you advise them to still monitor the news to keep them abreast with topics that could possibly inspire a bar question?
Well, definitely. Isolate, but do not isolate too much. Do not overdo it. You need to find an equilibrium. You need to, have balance, or else you'll break down before you even start the bar exam. It's okay to do selective monitoring of the news, meaning only watch or read the ones that are considered as major events. Don't go to the local news or trivia, or the usual news where somebody hacked somebody, a policeman shot somebody. Just go to the news that are relevant to the subject matter that you're trying to study for. For example, this is political law, so watch the news about the ICC, what's going on with the International Criminal Court. Watch the news about the Senate hearings, or the congressional hearings. What else? You watch the news and find out what they're saying about amending the Constitution. These are news articles that will help you understand real life application of the things that you've just read. It will give context and will provide a real world application, so that you can better correlate them, and then by listening and watching news, you will be able to apply these concepts and understand them. So by all means, concentrate, isolate, but find time also to scan the news. It will benefit you a lot.
Number 2, could you share any tips on how to study smart during pre-week?
The pre-week is very short. It's a very short time for you to be going back and studying all the materials that you've gone over. So my advice is to concentrate on frequently asked questions, or questions asked more than once. Because the truth is, the questions that they will ask you have been asked before. They will just change facts. But there are only a few bar zones where examiners can get exam questions. So because of the short time that you have, stick to codal provisions. Try to remember, memorize, and go over the major provisions of law that are always quoted, that are always made basis of your answers. For example, eminent domain, just memorize. Private property should not be taken for public use without payment of just compensation. Things like that. Because if you can answer, if you can put the black letter law, it speaks a lot about your preparation, and you will get points for that, definitely. Because it's the pre-week, you need to practice answering. Simulate that you are already in the bar. Try to do the tried and tested format that we keep on telling you. When you answer, put a categorical answer on the first part. Then cite your black letter law, either the provision of law or jurisprudence. Argue that by relating the facts to the issue. And then just make your conclusion. That's a tried and tested format. And if you answer that way, you will get points. And finally, because you don't have time anymore during the pre-week, sacrifice some more. You've gone this far. Do not let distractions derail your study, or else sayang naman. You've sacrificed a lot already, and you're almost there to the finish line. And so, konting tiis pa. And of course, stay calm. Do not panic. Because if you panic, you'll be under stress, and you might get sick. So, self-care. do not panic. Just find a balance. Um, your friend is the syllabus. Your bar chair said that 101% of the questions will be taken from the syllabus. So please make use of the syllabus. It's in the bar bulletin. It's in the first bar bulletin. So what you do is look at the topic and then recall as much information as you can. Go over the topics one by one. You will not go wrong. And if there's a topic that you don't know the answer to, or you forgot, then just go back and look it up. But the important thing is you cover the entire syllabus. And then, as I mentioned a while ago, you have to hone your answering techniques. You practice using ExamSoft, or even just typing, so that you can type faster, you can erase errors faster. There is no more time to learn during the pre-week. So what you're doing in the pre-week is you are just reinforcing the things that you already know. So you just focus on key concepts. Do not bother going back to the textbooks, or else you will just make yourself nervous. You will just panic. So there, I hope these tips can help you. And again, I'm honored to be here to assist you in your bar journey. So good luck and God bless.
As mentioned earlier, our lecture today for Political and Public International Law is just one of our many lectures for the Central Book's Best Pre-Week Ever, as we also have those for commercial law, taxation law, civil law, criminal law, labor law, and legal and judicial ethics with practical exercises. All of these are happening this September 2024. Like and follow the page of Central Books to remain updated with the dates and speakers for each program. We would also like to recognize our main sponsor for this initiative, Central Books, as well as our main collaborators, PUP College of Law and ALSP National. And that's a wrap. Thank you, everyone. Before we end, let me leave you with this quote from Cheryl Strayed. Go above your nerve. Good luck, future attorneys. We are rooting for you. I am Fernella Jimenez, your host for today for Central Book's Best Pre-Week Ever. Thank you for your time.